Hi, I'm Stuart Clark,
And I'm Sayuri Kagami.
and welcome to Hall in the States. You are listening to episode number 550.
And today we're discussing the issue of damages on an application to pass accounts and attorneys for property.
Yeah. Well, hi, Sayuri. It's our first podcast together. It's kind of, exciting first for the two of us. So, as Sayuri said, welcome. We're discussing kind of an interesting procedural issue, perhaps, debatable issue, perhaps. I wrote a blog on this relatively recently, the question being, can you pursue damages against an attorney for property within an actual application to pass accounts, or do you have to start a separate proceeding? And from the start, I'd like to kind of get it right out there. This is kind of an interesting academic, if not, specific point. I think if you ever raise it to the judge, they probably look at you sideways and say, what the heck are you talking about? I think I want to do what I want to do anyway and just order against you. But it's an interesting point that we can talk about, if only to help you understand better the process of an application to pass accounts by an attorney for property and an application to pass accounts as an estate trustee and what you can and can't do within those actual processes.
Let's talk about attorney accounts for estate trustees. Now, in those account proceedings, you can seek damages against an estate trustee within the application to pass accounts, correct?
Yes, exactly. And so we should kind of take a step back and talk about application to pass accounts generally. So, people are fairly familiar with the concept of an application to pass accounts, I like to think. But the basic concept is often, you either a beneficiary of an estate or you, a family member of a loved one who maybe has a power of attorney looking after them, think, gee whiz, the person's not doing a great job, and I want to know what the heck they're doing in the administration. You can seek an order if you believe that this is happening to you. You can seek an order under certain circumstances, compelling that estate trustee, that power of attorney, to pass their accounts. It's basically a court audit of what's going on, and in those accounts it will show, hey, I sold the house for this much money. Hey, here's what I'm doing with the investments. Here's the in and outs of the money, and you make objections in that. And as Sayuri alluded to, in the context of an estate passing of accounts, so say hypothetically speaking, an estate trustee sold a house and you think they sold it undervalued. You think, hey, I've lost $100,000 because you undersold that house. The Estates Act actually spells out that if the estate trustee has commenced an application to pass accounts, and in that you say, hey, look, you cost me money, damages, you can pursue that $100,000 loss or whatever it is, that damage, within the actual application to pass accounts process, which stops you from having to then start a new statement of claim. So without, so Section 49 of the Estates Act, and it basically says that on an application to pass accounts, the court can inquire into, any perceived negligence, breach of trust on the part of the estate trustee, and can investigate that and can order damages as against the estate trustee if they consider it appropriate.
All right. So we can do that with estate trustees, but when it comes to attorneys for property, you think that there's a certain little issue there and that we can't necessarily apply Section 49 of the Estates Act to the actions of attorneys for property.
Yeah, so as alluded to a second ago, the Estates Act, so there's actually a statutory provision, Section 49(3) of the Estates Act, that says when you're passing an application to pass accounts for an estate trustee, the court has the power to order damages, make full inquiries regarding any breach of trust allegations and order damages within that. That's a statutory provision, but it doesn't speak anywhere in that statute, to my reading, to the ability to do the same thing if you're a power of attorney for property. So the question which follows then is, so if you're a estate trustee passing your accounts, I can sue you within the application to pass accounts for that money, and the Estates Act says I can do that. But in the absence of language in the Estates Act saying that that provision also applies for power of attorneys for property, if I'm a power of attorney passing my accounts, does that mean that if someone in the no objection stage says, hey, you cost the incapable money and I think you had breach of trust, I'm going to sue you for damages, does that mean they can pursue those damages within the actual application to pass accounts? Or do they have to then commence a separate claim as against the estate trustee, if only because there's this apparent potential gap in the legislation? I think it is just that. It's probably a gap, right? I don't think there was ever an intention that an application to pass accounts or POA, the objector couldn't pursue damages within the proceeding, but because the Estates Act doesn't specifically spell out the possibility to pursue POAs for damages within the proceeding, the question is, well, does that mean you can't and you need to do a separate claim against them?
So You said, if you brought this in front of the judge might say, what are you doing? This is ridiculous. So what are some ways that a judge might address this potential gap? I know one issue we talked about was the Substitute Decisions Act, which governs attorneys for property and guardians for property, has at section 42.6 states that the procedure of the passing of accounts is the same and has the same effect as the passing of accounts of executors and administrators' accounts. So can we use that to get around this potential gap?
I'm going to give you a non-committal answer, which is maybe. Who knows, right? I suppose the question, so yeah, you're exactly right. So the Substitute Decision Act basically says, look, the procedure to be followed on any application to pass accounts for an attorney for property is the same as that for an estate trustee. Okay. Usually that directs you to the rules of procedure, and it sets out all the stuff of how you're supposed to have the application issued, what you're supposed to file with the application, who you're supposed to serve it on, et cetera, et cetera. So the question is, does that provision somehow pull in the language of Section 49 of the Estates Act to say, well, since you can pursue damages in the application to pass accounts on the estate side, because that SDA says the procedural procedures should be the same, that would pull that in. And it depends, right? I guess the question is Section 49 a procedural provision, i.e. is the ability to sue for damages within the application to pass accounts itself versus separate proceeding, excuse me, procedural in nature, or is it somehow something different? If it's procedural, you're probably right, maybe arguably, that then it's pulled in and there's no issue. But if it's found not to be procedural, well, maybe not. And I'm aware of no, case on point exactly to answer that for me. I can see why a judge who's being told, no, you can't order damages against the POA within the passing accounts, and not liking that answer may be inclined to say, well, 49.3 is procedural in nature, and therefore I can use it. But I don't know. It depends. It's also been suggested by some people I've talked to kind of on this point that, okay, fine, if I accept that there is this legislative gap and you can't pursue damages against the POA within the passing of accounts, well, the court's not going to like that answer. So either one, they're going to say, well, there's inherent jurisdiction of the court to somehow have these issues flushed out and to order damages, or also under, if you look back to some of the older passing accounts cases before they kind of flushed out and the rules of governance of how they were kind of before the court, there were these things called surcharge and falsification orders. Basically said, hey, you did a bad thing, and I'm going to order damages against you for doing that bad thing. And could you do that? And maybe. Again, it's all, maybe. It depends, As I said, I don't think a judge is going to like being told that, they can't knock the POA around a bit on the passing of accounts. But if you look to the actual statute, it's at least debatable that they may not have that power. But I don't know if I want to be the one to tell them that.
All right, so let's say you represent an objector then, and out of an abundance of caution, even though this is completely an academic question for the most part, you just want to avoid any potential risk that you might not be allowed to claim damages in a passing of accounts. Well, first of all, what are the potential risks that are involved in that case, and what can you do to protect your client?
Yeah, well, there's some debate still. So the big issue would be limitation period. There's some debate. I happen to think that their limitation periods do apply within passing accounts. There's some debate, do limitation periods apply to objections in a passing of accounts? Can you pursue damages within the passing of accounts for historic wrongs that are more than 2 years, or whatever the limitation period may apply to that claim may be? That's a topic for another podcast on another day. I think those do apply, but limitation periods kind of swirl all around this. So say in the hypothetical that you are objecting in a POA, an attorney passing of accounts, you file your notice of objection. So the alleged wrong happened coming up, a year and a half ago. You get your objection in before that 2-year deadline. So in theory, you're clear to the 2-year limitation period, which may apply against that claim for damages against the POA. But it's eventually found that, there is this legislative gap, and I, as a judge, can't order damages within this court proceeding that you've commenced for that alleged wrong. You then file a new statement of claim, which is now 2 years plus a day after the alleged wrong, and there's the chance that someone could say, you know what, you're out of time. You can't come at me for damages anymore. So to safeguard against that, I mean, it depends on how conscious you want to be, I suppose, and how much you want to read into this potential. But if you're coming up on a 2-year deadline, or whatever deadline you think may apply to your claim, and you know you're going to be objecting to that claim, or you may want to start a statement of claim contemporaneously with the notice of objection or with the application to pass accounts for damages in amount to be determined in association with any breach of trust claims. That will probably be the safest way. Whether or not it's necessary will depend on if the court ultimately finds there is this gap.
Well, it'll be interesting to see if anyone listens to this podcast and decides to make that argument and maybe give us an answer on that.
Yeah, no, exactly. It's an academic point. It's very, specific. I said a judge probably won't like being told they don't have that power, so chances are they'll find a way to get around it. But it's an interesting, at least, academic question, if only to help you understand the nuances and the procedure of how you bring claims against power of attorneys, executors, etc. But I think that brings us to the end. Sayuri, thank you very much for podcasting. First podcast with the two of us down. Hopefully many more to come.
Yep.
And should you have any questions, please feel free to email us at webmaster@pelhamhall.com or leave us a comment on our blog. Thank you very much. I'm Stuart Clark.
I'm Sayuri Kagami.
Thank you for listening.